Welcome, everybody, and thanks for joining us here for this edition of IPWatchdog Unleashed. This week, I have the honor of talking to my good friend Scott McKeown, who is a shareholder in Wolf Greenfield, where he is in charge of patent post-grant practice. He is also the author of patentspostgrant.com. He's one of the most prolific representatives in the PTAB arena, dealing with IPR, PGR. He also handles reexaminations and the like. And he's also a very good friend of mine. And he's the chair of our PTAB program every year, which we're doing this actually is live. We're doing in front of a studio audience here, this conversation as a part of our PTAB 2025 program. So welcome, Scott. Thanks for being here.
Thanks for having me, Gene. I don't know who came up with Unleashed, but I love the subtle reference to dogs there.
Yeah. We're big dog people. We have the dog wall in the back, and we're all and our German Shorthair Pointer Luna is very pregnant. I suppose you can't be you're either pregnant or you're not pregnant.
Yeah, you can't be half pregnant.
So, but she's like very pregnant in that she's gonna probably hatch in about 10 days or so.
Nice.
So we're gonna have some puppies, and big dog people. You're a dog person?
I am, but my kids want to be dog people, and right now I'm putting a roadblock up for that one. But
I see. So you're giving the kids the Heisman.
They won't take care of it. So.
Okay. Well, that's all right. I like you anyway, even though you seem to be against dogs in general. But that's fine.
I like them. I like other people's dogs.
You like other people's dogs. Okay, that's good. So thanks for doing this. And we've covered a lot of ground here over the last day and a half at the PTAB program. Did anything stick out for you so far as particularly interesting or enlightening?
I mean, I think it's like a lot of things in patent law where we recognize that there are some things that are not working optimally, but we're not realistic about how to fix it. And we talked a little bit earlier in the program today about subject matter eligibility and injunctions and PTAB, and we have a new director, and we're in this position right now where it's a transitional phase, and we could go in a number of directions, but it seems like, at least in DC, this is not unique to patent law, but the extremists are dominating the conversation, so we never get to the compromise that would actually work for everybody.
Yeah. I say it all the time that if you were to lock the parties in a room, we could agree on 80, maybe 90% of everything, but the margins, the cases around the margins, the behaviors around the margins just unfortunately define the debate, and it makes it impossible to get to a resolution. Add on top of that, if you will, that so many people have, well, I could agree to this if and only if you agree to my demand. Mm-hmm. And often the people that are like that will make a demand that is just so unpalatable that nobody could really ever agree to that. Or at least certainly not enough people to get a positive vote in Congress.
Well, I think the PREVAIL Act is a great example of that. I mean, it's very one-sided, very pro-patent owner, and you have inventor groups lining up to oppose it. They could not draft a more pro-patent owner piece of legislation, and the main people that would benefit, or a good portion of them, are coming out against it as if it's bad, and that's what I mean by, it's this all or nothing mentality. And the same thing goes with PERA, the patent eligibility. You had significant effort from Congress. I think there was 40 witnesses or something in 2 days, and so you have the attention of people that can help you, that put all of this effort into it, and then it just falls apart. I mean, it's hard enough to get attention for patent issues on Capitol Hill unless you present it as the AIA was a jobs bill, which of course was crazy. That's ridiculous. It wasn't a jobs bill. But that's sort of the extent you have to go to get the attention from politicians that need to go back to their districts and sell something like, oh, I fixed patent law. Nobody cares on Main Street about patent law. He said, well, I created 50,000 jobs. Okay, or I'm fighting China. And so you have to come up with these stories that are very far from reality to get their attention, yet we had their attention on PERA, and that seems to have fallen out of favor for what I view as kind of more extremist bills that just don't seem to be viable.
Right. No, and the PERA thing, which I will confess I know more about than PREVAIL, simply because that's my area of expertise is with software. You know, the arguments were made that this would make artificial intelligence related innovations unpatentable. And it specifically says in the bill that if the process or method occurs on a machine, it's patent eligible. So I asked these groups that don't think PERA is good enough, give me one example, just one. I just need one example of artificial intelligence that does not operate on a machine. And if you can give me one example, I'll think about it differently, and maybe I'll even be on your side. But of course they can't, because whether it's a robot or whether it's a computer or it's in the cloud, there's a machine somewhere. And I just don't understand what's going on. It almost feels like they just want to kill it because they want to keep complaining.
I don't know whether it's to maintain relevance, right? If it never gets fixed, then they'll always have a purpose. But the fallback argument they tend to throw out as well, you know, this definition in the legislation, we can imagine attorneys will argue about that. Well, what do you think is going on now? I mean, what do you think has been going on for decades? You've got Judge Michel and law professors and all of these people going up to Capitol Hill saying, we can't make heads or tail of this. You know, no one agrees. You know, there's parties that would like a strong, you know, change the subject matter eligibility. There's parties that kind of like confusion, but we all agree that it doesn't make any sense. And so, you know, rarely do you get at least that kind of consensus in D.C. So to have that, and for this still not to be any closer to the finish line than it was, you know, pre-COVID when they did all of those hearings, it's just frustrating.
It is extremely frustrating, and I don't know what to make out of it. And the other argument that you hear with this too is well, I could envision not just the attorneys arguing like you say it's not clear enough, but even the clauses of the proposed statute, the bill that are clear enough that they'll tell you, well, I could see a judge just ignoring that,
right?
Because they think the judges ignore the law anyway. Maybe there's some that do or some that don't. I don't know that they ignore anything as directly clear as what's in these bills. They interpret around the edges. Mm-hmm. So they're looking at that and saying, well, they're going to interpret this very clear statement around the edges in ways that contradict what it means. So I ask, so then what language could you possibly be okay with? If you think they're going to ignore the language anyway,
right? Then why are we fighting over it?
Why are we fighting? You can't support anything. And then they go, well, I do support this other crazy bill over here that goes way too far and has no chance.
I mean, short of a bill that said everything is patentable, you know, I don't know that you're going to get those groups to line up in favor of anything. And they're very active and they're very vocal and they're knocking on doors. And it just, I think, you know, there are some on the Hill that just won't talk to these people anymore, right? It's just, you're not going to get time with this rep or this senator because we've seen you enough to know that you're unreasonable. And so if they're leading the charge on some of these changes and that's sort of the view of those organizations, you know, they're kind of sinking the ship for us.
And they're not going to get anywhere. And there are some of the folks that walk around the Hill that are just not welcome in members' offices, not only because they're not reasonable, but there was some stories about surreptitious recordings trying to be made and that sort of thing. And I don't get this. You know, it's to what end are you trying to, the person who's there to try and help you, the staffer or the member of Congress who actually is trying to sit down with you, which doesn't happen all the time. Usually you only get to talk to staffers.
Right.
And you're trying to record them to do a gotcha. It feels weird.
Yeah, it's very tabloid, and a lot of these folks, it's almost like they have a vendetta against the entire system, and so it becomes burn it down.
Right.
And, you know, that's kind of where we are on some of these bills.
So if you had to guess, and we had a panel here talking about the various bills, primarily PREVAIL because that pertains most directly to PTAB, but we also talked about PERA and also Restore. If you had to handicap any of these during this Congress, what percentage are you at?
I mean, I think everyone yesterday was pretty consistent that for this Congress, there didn't seem to be like a lot, you know, a good chance that any of these things would progress. But, you know, maybe next Congress when, who knows, you know, there's a change in majorities and then there's a change in committees. And so I always thought all along that PERA was the most reasonable, seemed to speak to potentially national interest of, well, we have medical diagnostics, we need more of this, we need to incentivize these kinds of developments, right? I think we can all agree that medical diagnostics and things like that, let's fix this, right? Or, AI needs to be patentable and 101, maybe a roadblock right now. All of that stuff seems like there could be a consensus around it, and that one was the least controversial, not necessarily going to lead to more litigation, but yet the one that got out of committee was PREVAIL.
Right.
And it barely got out of committee, and I think it was a little bit of political theater, but so now there's this sort of distraction away from what seemed to be the most reasonable of the bills to, well, hey, that one got a little further along than the rest of them, let's go with that one. And I don't know that PREVAIL has any real shot. You've got ISA in the House. It's just a roadblock for a lot of those changes. And so, there may be a lot of effort that go into that one, and the Restore Act, which I just think is a non-starter. And again, we're leading with our chin on things that can be spun up as, well, injunctions, right? This is about litigation and what's going to happen when Huawei comes in and starts asserting all of the standards it's been patenting against U.S. companies, or Apple, or pick a large tech company is faced with being shut down 5 to 10 times a month. I mean, that's just never going to happen. It can't happen. And so when we leading the charge with some of those, what I view as losers, is just going to hurt the more reasonable stuff that we're just putting on the back burner.
Judge Michel seemed to think he was the most pessimistic about, and we talked primarily about PREVAIL and handicapping PREVAIL. I think he said he gave it less than 20% chance in this Congress. David Kapos was a little bit more. He gave it maybe 30% chance. And the most rosy was Chris Israel, who said maybe best case 50-50. But those odds are not good.
I mean, those guys are very close to the lobbying effort, and I wouldn't expect them to sit here and say, we have no chance, and then turn around Monday and start knocking on doors. So I think there was a little bit of that. But I thought Judge Michel was pretty forthright in acknowledging that there's a roadblock in the House to this stuff, for PREVAIL in particular. And so...
well, there may be a roadblock in the Senate, too, because I don't think anybody really understands exactly or knows what Senator Adam Schiff thinks about patents. He's pretty solid on copyrights, which isn't shocking since he's from the LA area. But I don't know that people.
Well, with Cruz, I think being a supporter, he's probably just going to oppose it just because. But
right,
So
that's the thing.
If you have Republicans lining up, House, Senate, whatever.
Yeah, that was the wild card. Was that if the Trump administration, whether it be the president or the Secretary of Commerce, really lean into this, then maybe you have a chance. And it wouldn't necessarily take President Trump to make more than a couple phone calls. As I think David Kaplan said, the president is not going to be working the phones. The president's going to make, maybe if they're interested, 1 or 2 phone calls, and then it would be up to the Secretary of Commerce to really say this is important to the president, important to the administration. And if that happens, then things could change. But nobody really, we don't even, the hearing is tomorrow.
Well, but I mean, to lean into it, it's, what's the reason? It has to be, as some of the examples thrown out yesterday. Well, it's to fight, China, or there's going to have to be this black swan event with technology where we can sort of pound the table to say, see, if we had, the PERA bill or PREVAIL or what have you, then this would be a great help. You need something to sell to the American public other than stronger patents, because that was tried for the last 7 years in a row. And it's just not sexy enough to take back to your constituents and say, look what I did. I tweaked this area of the law that no one understands but the nerdy patent attorneys. So,
but that was interesting that Judge Michel said that, we may need to have some kind of a, not his words exactly, but I think it's reasonable to interpret what he said, like a national security moment or crisis or fear vis-a-vis China in order to move things. And then overnight, while we were here having this conversation, news broke about the DeepSeek in China, and there's some people who wonder whether that's legitimate or not, because apparently they're using chips, old chips to do this. But if they are able to do what they claim with old chips, that could be the shocking moment that maybe we need to get, if not a better or different patent policy, a better or different innovation policy?
Yeah, I mean, that is sort of the sales pitch that they've been using for Prevail in particular, that it's helping to somehow, win this race with China. But that sounds good to the general public, but then you look at what's going on at the PTAB, there's no Chinese filers. The petitioners are disproportionately U.S. companies or, larger, foreign companies that are fighting, essentially, in a lot of cases, U.S. businesses that are, popped up. Litigation finance is propelling a lot of this. Not saying it's a bad thing, but when you talk about, and this comes up a lot at these events too as well, back in, 2003 or whenever, prior to, injunctions going away, we were able to do all of these great things, but there was an order of magnitude less of patent litigation then. There wasn't litigation finance to the extent we see it today. So the landscape is completely different. So this argument that, we did it before, we can do it again, I just don't think it's feasible with the number of lawsuits in this country.
Yeah, the number of lawsuits has gone down, though. I mean, does that worry you at all as a PTAB practitioner? Because the number of district court lawsuits have gone down, and the number of PTAB petitions has gone down. And does that concern you either from a business standpoint or from an overall health of the system standpoint?
No, because you can track a lot of that stuff to something, right? Well, the PTAB filings have gone down. Well, you can't file 9 petitions against the same patent and just say, well, I want 9 petitions, right? That ended, years ago. So that was one dent. And then when you introduce, which I expect will come back, some of these, more, just call them stricter or discretionary denial practices, maybe that, if you're in the ITC and there's a rule that if the ITC gets to their decision before the PTAB that you're going to get a discretionary denial, then you probably won't file one, because by the time you get your act together, you're 6 months into the ITC calendar. So you can track some of these trends, to a lot of these changes in policies and what was going on, in the Western District before they adjusted the assignment of cases there. So, there are ebbs and flows, but there's not drastic drops in either.
Mm-hmm. One of the things that you and I have talked about a lot and did come up here, and it's not the type of topic you hear at these PTAB meetings a lot, because a lot of the conversation about the PTAB focuses on the PTAB, reasonably, right? What's going on there from institution to final written decision. But I've always taken the position, I think you share it as well, is that many of these cases are won and lost by decisions that are being made by patent owners based on the budgets that they want to pay, which everybody in the prosecution industry knows. Most clients want to pay 1980 prices for 2025 work. It doesn't work that way. And there really is a difference. You can read patents and you can know whether they're written well and they're written good and they're tight. And they may not win at the PTAB. They may claims get invalidated. But you can also read patents and say, well, if this ever gets challenged, there's no chance.
Right.
And why doesn't that ever change? I mean, we talked about it. There's a lot of reasons, but what do you think is the driving force there?
I mean, I think it's budgets. I think it's, in some respects, just looking down on the prosecution end of the profession, and procurement is somehow not really legal, right? It's something else. They're vendors. We can have them bid, and we'll get these 6-page specifications with a 5-box flow chart, and we'll just have a box with some other boxes in there, and maybe we even outsource the drafting of this to some unknown organization, and we'll just churn these things out, and it's like it's cannon fodder, and we'll have enough of them that maybe we'll have a claim that survives somewhere along the lines. I mean, prosecution, as we've brought up here a couple times today, it's just been pushed. The budgets have been pushed down lower and lower, and it's the claims, it's the quality of the specifications, it's the strategy and the structuring of the claims, and understanding that picture claims could help you, or a random means plus function term, or, any number of things that you can do. You can do a lot of incremental things that add up to a patent that's a lot more difficult to challenge in a petition, or a lot more expensive. You've got a greater number of claims. You've got a diversity of terms. A petitioner has to come in and address all of that, and they can't do it in one petition, and now they're filing 2 and 3. So there are incremental steps you can do if you are sort of planning all of this out and understanding the world has changed, so you're changing your prosecution practices. But when you're bidding out your portfolios to the lowest bidder, you're not getting that level of strategy or sophistication. You're getting probably AI generated specifications, and they're just dumping in disclosures and getting probably claims that come out the back end because that's what they have to do to meet the budget. And if that's what your idea of protecting the crown jewels of your organization, you're going to be very disappointed. And the PTAB in that equation is not the problem.
Right. Does that surprise you in any way? I mean, I thought we were going to wind up getting gold-plated patents, as I used that term earlier, and that has a couple of different meanings, right? We thought that with the estoppel provisions, if the patents survived PTAB, that they'd have the gold plating to some extent. But I also thought much more directly that what you would see is you would see people drafting applications with an eye towards, hey, this is likely going to be valuable. If it's valuable, by this point in time, we know if it's valuable. The odds of it going to the PTAB are pretty strong. Mm-hmm. Certainly if you're going to use these assets for a enforcement or licensing regime, it's very strong likelihood. So I thought that more time and energy would be spent, and I thought that maybe these patents that you might get because somebody is celebrating their 40th anniversary with the company, or the CTO or CEO came up with some crazy idea, those would get taken off the books, because you can't have it all. You can't have the patents that are no better than hanging on the wall framed when you're trying to survive through the PTAB. It just doesn't seem to have worked out that way.
Well, I think there's always been this lack of communication or respect, or whatever you want to call it, between prosecutors and litigators, or those who are doing the strategy. And so, the feedback coming from the litigators to the prosecutors, or the prosecutors showing the initiative to watch what's going on to the portfolios they're building, and learning from this sort of feedback loop that doesn't exist. So that's part of the problem as well. Is a lot of prosecutors are perfectly happy to do what they do and look at the goal of their job as, well, I got an allowance today, or got another track 1 through. Maybe no one will ever infringe the claims ever, because they're garbage claims. But my goal is to get patents, or my goal is to get allowances, where the goal should be to get patents that matter to your organization, and get claims that you can litigate. And if you do have those patents or those claim sets that you already know are important to your company, like I said, there's a number of things that you can do to make your patent that much more difficult to challenge, whether it's having 30, 40 claims in there, having means plus function terms. Even if they're not great for infringement, someone has to construe that in the petition. So that's going to burn up word count. If it is in litigation, they're probably committing to that construction before they know what your view of it is. If you've got products that are out there that are performing well in the marketplace, you get a statement of reasons for allowance. Pile that stuff up, keep it at your desk, and send it all in. Hey, examiner, I saw what you said about my claims being allowable. Here's all this additional stuff. Yes, it's self-serving. The examiner's going to completely ignore it. But when it comes time for someone like me to file the petition, I have to address that. It's secondary indicia that's in the it's in the record. So now I've got a means plus function construction. I have to address secondary indicia. Maybe there's 40 or 50 claims. Now I've got 3 petitions. You're varying the language of your claims. It's not lazy prosecution where the apparatus and method claims are basically the same functional language with the structure pulled out. Vary all of that, have meaningful dependent claims. Now it's a problem for me. I've got 4 or 5 petitions. I'm committing to constructions that I don't want to commit to yet. I have to get different grounds for the dependent claims because they're not throwaway claims. They're meaningful things. So now you've mushroomed what, if written in an old style, 5 really broad claims, I can do, very easily a 2 or 3 reference combination. There's none of that conversation. I'm not committing to really anything that's going to bother me, as opposed to, now I've got 4 or 5 petitions and I've got to worry about all this other stuff. So there are things that people could do prosecution-wise to learn from, what is essentially, right, the first hurdle to monetization is now the PTAB. It's no longer, I have to have an infringement. I mean, of course you need an infringement case, and I've told this story, I think, here before. When I was prosecuting, I drafted the application. I've got elements A, B, C, and D. The partner comes in, what's with this element D? I said, well, that's the point of novelty. And he said, well, yeah, get rid of it. And I said, well, then we're left with A, B, and C, which is the background, which I know because I wrote it. And the response was, you let me worry about that, just get that claim. And so, because that was the game, right? You can't make up facts to prove infringement, but you can dance around obviousness in the district court. And since, the first hurdle is the PTAB, it's a little bit different now. And so it's still mind-boggling to me to see how much prosecution has failed to adapt and how much patent owners, coming into the PTAB are still trying to play it like a litigation and, trying to say as little as possible about the technology and using these sort of, let me dazzle you with my advocacy brilliance kind of arguments that just, in front of an expert agency where all they're concerned about is the claims and the technology. That's just a losing strategy.
Yeah, it feels like these are not the droids you're looking for kind of argument, and that's not going to work. And what's frustrating to hear you sit there and talk about all this stuff is the litany of things you just listed that you could do to make it harder, and maybe not harder isn't the word, more expensive.
Right.
And sometimes harder because of the page limitations and word counts and that sort of thing. But they wouldn't take a whole lot of engineering to do this, right? Yeah, you'd have to pay a few more claims fees. You'd have to write your claims and chain them all together. So if you want to challenge claim 10, and you got to challenge claims 1 through 10, but it's not that much harder. And the other thing too is listening to you talking about means plus function. You probably threw that out there because that's a big. I just don't get it. I mean, and I talk to litigators all the time, and they where are the means plus function claims? Why aren't you prosecutors getting means plus function claims? And there's a whole bunch of folks, lawyers teaching or law professors teaching in law schools saying don't get means plus function claims, they're all too narrow, and the law is different. I get it, and it's certainly different, even more so when you look at it with respect to computer software type claims. It means plus functions don't mean they're the same thing that they mean elsewhere. But these claims have a purpose. Are you ever going to get a client that tells you, file as many claims as you can to cover everything that you drafted in the specification? And the answer is no. Mm-hmm. So having a couple means plus function claims that cover the full extent of what's in the specification just makes sense to me. The other thing I'd like to get you to comment on is the Williamson case, which kind of made everybody really scared. Now it's not just means, it can be any language or whatever. I think doesn't that case more or less just stand for the proposition that if you don't have it in your specification, then you can't have it in your claim? And I mean, I don't want to lose my card as a patent maximalist here, but I think that a lot of things, the sky is falling. The sky's not falling. The sky's falling, if at all, because of the choices you're making strategically.
I mean, I think the bad reputation that means plus function claims comes from, really two issues. Number one, if you're not paying for a quality specification, then your means plus function claims are useless.
Yeah,
because
totally.
If you're referencing a box that is your means for transmission or what have you, it's indefinite, and so therefore you lose. But the problem I think that always came back from the litigation side is, well, they're narrow. I'd rather just have a regular broad claim where I can say it covers everything.
But you can have both. There's no reason why you can't have both.
Well, I mean, what it comes down to at the PTAB is, would you rather have no claims or a means plus function claim?
Right.
So it's a hedge, and it's an incremental step you can take to make it more difficult, because then you have to have the conversation with the litigation team of, well, we need to file this petition quickly because the discretionary practices have changed and faster is better. Mm-hmm. And we don't know the other side's infringement case yet. So are you comfortable filing this petition now? And so now, not only are you making it incrementally more difficult for that decision to be made, but now you've got the discretionary sort of practice working to sort of drive you into doing it faster. And so as a patent owner, that's a pretty good place to be, right? Let them file it quickly. They don't know my infringement case, and if they don't file it quickly, then I'll argue that it should be discretionarily denied. So, I mean, to me, it's just prosecutors being plugged into what happens post-grant and organizations understanding the value in just not doing the prosecution the way they've been doing it, since the beginning of time, because the back end of the system is vastly different than it was, 20 years ago, 15 years ago.
Yeah, there's no doubt about it, but I don't know that prosecution has evolved. Some of it has, and I'm not going to name any names, but I mean, there's some people that really know what they're doing, that do really well. And I've got a couple friends up in New York. They do a lot of software work, and they tell me they never have an Alice issue. And it's like, well, because you're computer geniuses. You know how to describe these things. You don't treat it like a black box. And when you said you'd have a box, I can't stand these flowcharts where it's box line, box line. I mean, you might as well be begging for it to be either one, ineligible, and if you come over that hurdle, it's going to be obvious as hell. Because as it turns out, a line is not a flowchart. And the way that you get these things done is to explain what really is going on behind the curtain.
It seems to the companies, I think, that do the best on the prosecution side are usually in the life sciences, because they understand that they need to be aware of restrictions and what double patenting could mean on the back end. So there, at least in that industry, there's some coordination in terms of what are we filing, how are we structuring the claim sets. Let's sort of flesh out the family tree. What's it look like? What are we claiming and why? So, the resources, I think, at least in that technology, are being put into that. And, even though they're in the unpredictable arts, I think that's why those patents tend to do better. And yeah, they tend to also be very narrow, very, focused in percentage, composition, all that stuff is very specific. But you just don't see it in the unpredictable, or the predictable arts rather, where it seems more quantity over quality is the name of the game.
Absolutely, and I thought those days were long gone, but they're not. They're just not. Before we run out of time here, I want to pivot so this is a hard pivot for a minute, but LKQ. Now, when that happened, I talked to you, and you're like, this is probably not going to be much to see here. Design patents don't usually find their way to the PTAB. And I remember telling you, I was like, but like no design patent is valid anymore, it seems to me. But that hasn't been the experience yet, right? It's still at the PTAB. There's not very many design cases, and somebody here said maybe even less than there were.
Well, I think there were always a small number, and then I think the bar sort of realized, well, the institution rate was like in the 40 percentile, because no one really understood what the obviousness test was, because it was different from what you did in utility patents. But I think a lot of times in the legal profession, we wait for somebody to be the guinea pig and somebody to file something. We can say, hey, look, it works. And then, then everybody else sort of piles in. But, design patents just aren't litigated as much as utility, so that's part of it. Certainly there's some advantages to litigating them given the damage for the full product and all of that. But I think that's the real story, is that they are very narrow, and there's not a lot of litigation around them. So it will be interesting to see at some point if someone takes a patent that was challenged at the PTAB or even in the district court under that old Rosen-Durling test, and then says, well, let's try this art again and see if there's a different answer. But I haven't seen that case yet. Yeah,
I just thought that the people in the secondary markets for like auto parts, and maybe even some of the knockoff folks in the like sneaker area or places like that might see this as an opportunity to come out from under the knockoff people, to come out into the open and actually, but I guess they're just interested in knocking off and counterfeiting and stealing. And
most of their defendants are default judgments, and
right.
they're not too worried about validity usually, given how narrow the scope is.
Although I'll tell you, I think if it winds up with a lot of design patents getting killed because of LKQ, that would be some piece of legislation that could move, because the people that get the most design patents, they're the Adidas and Nikes, they're the car companies, jewelry companies. It's not independent inventor. It's somebody that's really trying to stop a knockoff or somebody coming in from a secondary marketplace. And they would just, I think, have a lot more juice in Congress.
Well, maybe they wouldn't be saddled down with some of the advocacy organizations we have. So.
Yeah, no doubt. The other thing I want to ask you about, because we did an article about this, and I think you were representing the petitioner, I think, and it dealt with plant patents at the PTAB. And I saw this, and it kind of went across my desk, and I saw this, and I'm like, this is kind of a little bit interesting. And then you were on the petitioner side of that, right?
Yeah, I work a fair amount in the transgenic seed space. Not that I know anything about it. But.
Well, I can't say I know anything about it, and I can't say that I really understood the argument, because it seemed, maybe I did understand your argument, because it just seemed like crazy.
What goes on in the plant utility patent space, to not plant patents, this is different, plant utilities, is beyond insane. The allowance rate is like in the 90 percentile. You can get a Plant Patent Variety Act certificate, which is just literally just a list of, stalk height and the width of the leaf, and then you just cut and paste that. You put it in a utility patent, and you get the patent too.
So you get a plant patent and
you get the certificate
utility.
And you get the utility, and they have different strengths for stopping research and things like that. So it becomes this assembly line of get the certificate, get the utility. And, a lot of times the parents for these hybrid plants aren't disclosed. They were maintained as trade secrets. It's a complete racket. It's probably not all that interesting to most people, but, it does harm farmers. And there's a number of cases I have going that we're trying to push back on what was originally the proper way to handle. The utility was always more difficult to get than the certificate, but that's now just sort of over time, just the distinction has completely disappeared, and so I'm working on some challenges there to get that in front of the federal circuit.
So what caught my attention about that is, you say maybe this doesn't apply to many people, maybe people don't really care, is I think not enough people feel the pain of the craziness of the patent laws. Like if KSR were really applied the way it was written across the board and not just to the predictable arts, there'd be a lot of things that wouldn't be patentable because they'd be obvious. And then there would be change made. If the 112 requirements were applied across the board in a whole lot of other areas, like this one, for example, there'd be a lot of people who say, what are you talking about? This is terrible. This needs to be fixed. And it does seem to me like we have a patent system where there are rules that do not get applied across the board. I know they're written and they're supposed to be applied across the board, but they get applied differently in different sectors within the patent office, for example. And that just irritates me.
Yeah, I mean, it's as I said, it's very stark in the plant space, but it's such a small niche practice that it can go unnoticed for a long time. And you've got huge players in that space, billion-dollar companies that have been doing it for years, and it's hard to budge the agency off some of those practices just because it's, it becomes, well, this seems really policy-ish, and maybe it is wrong, but right, that's above our pay scale kind of thing. So
we're just going to keep doing what we've been
you go
doing.
Figure it out someplace else. So, it's been an effort on a bunch of different fronts.
So this has been great. I really appreciate you sitting down and having this conversation with me. Mm-hmm. If there's one thing that you would wish that, maybe I'll ask two questions or from two different perspectives. If there was one thing that you wish petitioners knew, if there's one thing that you wish patent owners knew and really knew it, felt it, really internalized it, and no hand waving, what would those things be?
I think for petitioners, this goes back to the previous panel, is that this is not, it's litigation-like, but it's not litigation. And so a lot of times petitions that fail come in and they're written almost like preliminary invalidity contentions, which is, well, reference A has most of the elements, reference B has the last one, KSR, I'm done. And I'm not going to tell you about all my technical reasoning for why you would modify the first one with the second one. Just take my word for it, KSR covers me.
That is really these are not the droids.
And those petitions aren't getting instituted, so it is it's a 103 court, as I've said, you know, a million times, and so it's a technical story. You're not holding anything back as petitioner. Your petition will define the metes and bounds of the trial, so you can't hold anything back, or you're going to be limited from raising it later. So I still see a fair amount of people sort of treating the PTAB as well. I heard it's a death squad, so I'm just going to crank this petition out and it's going to be a winner. It doesn't work that way. You know, and for patent owners, I think we've talked about this throughout the program, is you can't approach the PTAB as if it's the district court and you're playing defense, right, where there's a clear and convincing standard and all these arguments that are coming in from the defendant, right, you're just playing defense, right? You know, they have to win on one. I'm just going to, you know, bat them away, where I see that a lot at the PTAB, this sort of mindset of, well, all right, the trial's been instituted, but I'm just going to throw out all of these arguments and it's up for the other side to disprove them, and it's not. You know, the burden remains on the petitioner, but once you get institution, it's really not on the petitioner, because you've already got 3 judges that have looked at this and said, well, I mean, this isn't our final determination, but it looks pretty good so far.
Yeah, it looks pretty bad for you, patent owner.
So as patent owner, you have to move the needle. You can't just, you know, throw things back for the other side to knock down. So it's surprising to me how many patent owners still just follow that same sort of district court game plan, and you know, it's just they've lost really before the trial started, because you know, I'll see briefs come in that say, you know, can you believe that the petitioner admitted that there's a missing element from reference A, and they went as far as to find a second reference, reference B. There's 2 references. Can you believe it? I mean, I'm sure that works well in the district court, where obviousness is an uphill battle, but in front of a court that day in and day out is mostly analyzing obviousness, you're just losing credibility out of the gate, and I still see arguments like that to this day.
That's shocking, but all right, well, great. Thanks so much, Scott. This has been wonderful. I really appreciate you being here. We'll have to have you back. We'll have to make this a routine thing. It's always good talking to you.
My pleasure. Thanks for having me.